One more time, let's get the legal analysis of today's developments in the Alec Murdaugh trial from the host of the Nothing But the Truth podcast, criminal defense attorney David Bruno. Thank you for being here, David. I just want to play a little bit more of what the judge said today, talking about Murdaugh's apparent addiction to opioids and how that, in the judge's view, may have played into all of this. Listen here to the judge.
It might not have been you. It might have been the monster you become when you take 15, 20, 30, 40, 50, 60 opioid pills.
David, the judge pretty damning in his indictment of Alec Murdaugh. Are you surprised that he was so outspoken in the way he dealt with this?
No, I was not. Look, he was sitting for this trial for 6 weeks. He was also the judge that signed search warrants. He's been intimately involved with the case from the very beginning. You know, that clip that we just played was right after Murdaugh said, "It wasn't me. I would never hurt my son. I would never hurt my wife." And I think that was a response. Maybe it was you as the person, but not the type of person. Maybe somebody that was under the influence, you know. But one of the things that I thought was exceptional was when the judge said that your family has been prosecuting cases since 1910, and they have put people to death. They have put people to death for far less than what you have been convicted of, and in essence saying that he thought that maybe the death penalty would have been appropriate for Murdaugh,
right.
But that wasn't his decision. That was the prosecutor's decision not to bring that death penalty case.
So, David, there was a lot of talk of how quickly the jury came back here, about 2.5 hours of deliberation, and apparently they were all pretty much agreed after 45 minutes. Given that, and given the circumstantial nature of some of the evidence, are there any grounds for appeal, as Murdaugh's attorneys say they will file here?
Absolutely, there's grounds for appeal. I've been vocal about this when the judge made the decision to admit the financial crimes, the roadside shooting, and the boating judgment or civil case when it happened itself. Look, generally, we want prosecutions based on the facts of the crimes and the offenses, not that people are bad people or propensity to commit crimes. Here, the prosecutor made an argument that all supported motive. And a lot of people thought that the nexus between those acts and the motive were weak. And at times, the prosecutor used it for more than just motive. There's a limiting instruction at the time of the admission of the evidence as well as the final jury charge that you can't use it for any other reason. You can't use it that he's a liar. And the prosecutor used it at times for the fact that he's a liar. He is a liar about the video and the kennel and being down there, but the use of a liar about the client relations and what he did to his law partners shouldn't have been used in that fashion. It should have been tailored as motive.
All right, David Bruno, thank you very much. Good to see you tonight. It took
Always
6